Dictation will start in 5 seconds. Syed Ratanbhai Syed versus Sirdhi Nagar Panchayat. Facts: appellants faced displacement on account of widening of road for development purpose. Full stop. Consecutive adjudications affirmed displacement. Full stop. The 5 appeals impeach the consecutive adjudications in sequential phases, affirming the displacement of the appellants by acknowledging the mandate of the relevant town planning and municipal laws and the overriding public interest as perceived, their decree being construed to have been rendered inexecutable by the intervening developments. Full stop. Their possession, however, remains protected by the interim order of status quo granted by the High Court and continued in the instant proceedings, subject to the liberty granted to the respondent Sirdhi Nagar Panchayat to take any action in accordance with law in connection with the widening of the concerned road or removal of encroachments. Full stop. The issues that arose inter alia were: number 1, whether the appellants were rightly declared as encroachers and were liable to be evicted? Number 2, whether the appellants were entitled to rehabilitation or compensation? Para decision. The maps/plans referred to in the course of arguments do prima facie reveal that the site in occupation of the appellants do come within the control line fixed under the Highways Act. Full stop. The municipal council, meanwhile it has undertaken the exercise of widening the roads concerned and has cleared the area of the encroachments, and that except the structures of the appellants, the operation is otherwise complete. Full stop. The growingly felt exigency of clearing the area of the structures and encroachments in conflict with the statutes involved is in the preponderant public interest, and it would, thus, be apparently inexpedient to trivialize the aspects of safety, security and convenience of the burgeoning devotees and the local population as persistently highlighted by the respondents. Full stop. Any contrary view, in disregard to this otherwise salutary cause, would signify a retrograde step in the context of greater public import. Full stop. The appellants have been consistently held not to be encroachers or trespassers on the land in their occupation, they having been let in thereto by the erstwhile Gram Panchayat, the then owner thereof. Full stop. Though the build-up of facts, since the compromise decree cannot be discarded, the contemplated measures of the respondents, to clear the area of the encroachments in public interest and for its overall development, would result in the displacement of the appellants as a compelling necessity. Full stop. As a corollary, they have to be essentially rehabilitated or adequately compensated, bearing in mind, the impact of the passage of time on demand of public interest, in the facts of the instant case, thus deserves precedence. Full stop. Para. The consequence of the appellants being uprooted from their present sites of business, to reiterate, would spell an overall dislocation in their lives. Full stop. Their eviction would assuredly eventuate a human problem, full stop. Nevertheless, for the cause of paramount public interest, their eviction is unavoidable, full stop. In case the endeavor to identify an alternative plot does not yield any result in spite of sincere efforts, the appellants would then be entitled to adequate monetary compensation, full stop. The appeals were dismissed, however, subject to the above terms, stop.